Hey everybody, thanks for joining us. This will be about mastering privacy contracts. Dave had this idea a little while ago that, there aren't a lot of, or at least we haven't seen a ton of webinars talk about some of these practical skills like privacy contracting. So we thought this would be a useful session. So let's get started. All right. So rough agenda is the what, the where, the dynamics, and kind of common issues. So what is privacy contracting? Let's talk about that a little bit first. It typically addresses personal information, which is a pretty broad category, just to be clear. Personal information doesn't just mean like PII as the US concept, but it could mean special categories of data. It could mean behavioral information. It could mean healthcare data, depending on the field you're in. And we'll talk a little bit more about scope later on. But in general, privacy contracting is around personal information. Where it gets a little hairy, and I think all the folks on this call have seen, is in what I call the adjacencies. If you have ever worked with or for or purchased software, software doesn't always have data that's only structured as personal data. I tend to call it like unstructured or adjacent data for that reason. So like, typically you might see the word customer data. And the reason why you'll see these other things pulled in is really because if, for example, you're recording a webinar or you're making a data inventory through a tool or anything else, while they don't necessarily require personal information, it can't necessarily be controlled what's in them, right? You could have all kinds of things in a webinar. Dave and I could record a webinar talking about how to make awesome burritos, and then Kathleen and Kate could make another webinar that maybe is talking about specific, people, places, and things or themselves that's totally personal. And so that's why you'll sometimes see privacy contracting in the realm of something far beyond personal data. So where does it, why does it happen? It's frequently required under a variety of laws like GDPR and CCPA. Why is that? It's because under things like Article 28 of GDPR, if you're a data processor, it literally says you need to conclude a contract. And so that's why there's these requirements around paperwork. Similarly, under CCPA and CPRA, if you're a contractor or a service provider, et cetera, or if you're engaging in the sale or share of information, as we've learned with both the Sephora and Honda cases examples, in the CCPA cases, you typically need an agreement in place. It's often conflated with security provisions, and there's a really good reason for that. They are siblings, right? But it's a little weird because privacy terms frequently do reference things like TOMS, technical or organizational measures. In fact, those are required if you're using EU model clauses or similar clauses in a lot of situations. However, it doesn't go both ways. Security terms don't really need privacy terms in them, although they can have them. But privacy terms frequently do require a provision around security disclosures, for lack of a better word. And the easy way to think about the dynamics there for those of you who are still kind of grasping the privacy versus security paradigm, let's think about a bank, right? If you think about a bank and you think about somebody building one, the thickness of the walls, the bulletproof gate or door, the guards in the front, all that stuff, that would be a security addendum, right? That's where you would outline those things that you need. We need, 6 foot, deep walls that, you can't break through or whatever, versus privacy, which is, what happens to the contents within that bank, right? Beyond the stuff securing the outside of it, can the bank employees go in and go through your secure deposit box? Can they go through your trinkets and copy images and photos and borrow your money for a while? That's a different topic about banks altogether. But point just being that like the idea is that they are different, although they do go hand in hand and they're closely related. And finally, they're not always, actually not finally, second to finally, they're not always negotiable. And what I mean by that is it could be for a variety of reasons, a lot of which we will talk about. But some of them are just to bring those up to light, is they're not negotiable because they're not allowed to be. For example, if you're going to use EU model clauses to transfer data between borders, those are dictated by the European Union. And there are some things you can adjust in them, but largely they're pro forma and you can't edit them. And if you edit them, you could actually nullify them. Some things aren't negotiable because they're not actually contracts. They're disclosures or notices for transparency, like a privacy policy, and we'll talk about that a little bit later. And some of them aren't because of dynamics, which we'll talk about soon as well. And finally, like I said, a number of them are, one way to transfer data across borders when there aren't other options available, like adequacy.
Thanks, Val. So I think you teed that up nicely. As Val said, the term data or privacy can be referenced in a number of different documents. So we figured it would be nice to break it down into those which are company docs, which are traditionally non-negotiable, and those that are contracts. So I'm just going to touch briefly on what they are because we're going to get further into the substance in later slides. But with regards to company docs, as Val mentioned, a privacy policy, some may reference it as a privacy disclosure or a privacy statement. It's a document that explains how your website or business collects, uses, and stores or shares personal information. If any of us have been to a website, usually you can scroll down, click on a privacy policy. So this should be something that all of us are pretty familiar with. Next, we have our sub-processors and affiliates disclosure, which is where a company will provide information about the sub-processors that they use to process a data subject's personal information and potential affiliates if that's applicable as well. Val also mentioned the TOMS, or the Technical and Organizational Measures, which is a document that sets out an organization's privacy, security, governance, and compliance commitments, including the administrative, physical, and technical safeguards that are designed to protect data from loss, misuse, unauthorized access, disclosure, alteration, and destruction. So this is a chance where your security team can work in conjunction with you to set out a document that clearly lays out what you're doing internally to protect data. And lastly, with the company docs or cookie policy, if your company is dropping cookies, this is where you have a chance to highlight your company's stance with regards to them. But the meat and substance, I would argue, for this webinar in particular is contracts. So we have 4 listed here, which are the terms of service, the data processing agreement, your security addendum, and your BAA. The terms of service, or EULA, if in the case of a reseller arrangement, is where you're going to lay out not just your commercial terms, but there may be certain aspects that touch on privacy. I know that personally, I like to include maybe your caps for limitation of liability or indemnity within your terms of service or your MSA, which we'll get into that a little bit later. But it works in conjunction with your DPA if one is necessary. But the DPA, I'd argue, is where a lot of what we're going to be discussing today is, like, where that information can be found. So it's a legal contract between a data controller and a data processor in which you determine the rights and obligations of the parties involved in the data processing. So, like I said, we'll get into each of the clauses a little bit later on, but this is just kind of like a where is it to be found in a high level. And as Val said,
Do you want to
Yeah.
talk a little bit about to the audience about what a sub-processor is in case they aren't familiar with the term?
Well, sure. Do you want to take that?
Yeah, either one. I just figured it might be helpful for folks who are still kind of new to it or are operating outside of Europe. So sub-processors are typically your, if you're a software company, for example, or in a number of other spaces, there would be your downstream vendors that you might be using to process data, for example. So in a sub-processing situation, if you're a SaaS company, for example, and you're using Amazon Web Services for hosting, they would be a downstream sub-processor. And so in contracting, you might not have your customer might not have privity with Amazon, but you do. And so you would typically have some kind of mechanism to disclose who you're using downstream.
Thanks, Val. So your security addendum, this may or may not be included in every contract negotiation, but as I mentioned to Tom's earlier, that's where your organization has a chance to lay out what they do internally to protect data. But some customers might want extra commitments with regards to your security posture, or have, a chance to kind of include some of what they might want to see that's not included in your TOMS. I have seen other entities try to force TOMS on people, but I typically like to argue for ours, using ours, because it's where we showcase what we do. But then use the security addendum as a means to negotiate maybe some nuances that weren't included or that they'd like to see. And then lastly, your business associate addendum. This is not applicable in every instance. This is specifically, if under HIPAA, if you're a covered entity is having you, a business associate, act as a certain, take on a certain of their obligations, then a BAA might be necessary. So we'll lightly, I think, touch on that later on. But if you have further questions on that, I would put them in the chat, or we can touch on them with you offline later.
Awesome. Thanks, Kathleen. And one thing that is a great segue into the next slide here. I'm hoping she's okay to do it. If not, we'll cover it. Is considering in the prior slide and in this one kind of what is B2B versus B2C, because some of those terms and your ability to actually negotiate them greatly differs, as well as actually what you need to disclose and share in terms of who you're speaking to. And I see a question here, so I want to make sure that it's not let's move to the back prior slide since it looks like Kate might have stepped away for a second. Do you typically see sub-processors being identified only by processing personal data of the customer or any data processed by the customer? Love to get your insights. So I'll take this one, but curious to hear from the rest of the panelists if they have a differing view. Um, if it's data being processed by you on behalf of the customer, I think that's where it's really important to think about the point that I made earlier about customer data as an adjacent or broader term. If you're handling information on behalf of a client or customer and you're in a processor or service provider arrangement, it really depends on kind of what that information is. But if it could or may or is likely or possibly could be personal information, you'll typically see a broader subset and people will typically say, hey, these are the sub-processors processing customer data, not just personal data. Now, it's a risk decision. You could conceivably still be cheeky and carve it out. But I would say that if you're in the type of business where what you do necessitates broad swaths of unstructured or open levels of information ingestion, that you consider disclosing kind of everybody. So for example, like a trust arc, if you're using our data inventory tool, it's really not specifically for like putting in a bunch of contact information. Although, as an example, you could be putting in your DPO contact information, which is personal data conceivably, or you could be uploading a contract as evidence of something, and that could have personal information in it. And so because of things like that, we would use customer data as the litmus versus just personal data as the narrow point. Um, and of course, there's also data that you as a business might use that doesn't fall into this at all, right? And I've seen a lot of organizations conflate the two. You as a company might be using Salesforce or Slack, but if you're not using them for and on behalf of the customer, but as a business administration tool, you should really be asking yourself, in my opinion, whether or not it's a controller relationship because you kind of control the destiny of that data and you're using it for your own business purposes versus what you're using strictly within the confines of these privacy contracts and under that privity structure that we talked about earlier. Anything else any other folks on the panel have to add on that one?
I just think it's a really gnarly issue. Like it's something that I think that we grapple with all the time, right? Like what is the scope of who we're disclosing? Because we know when we make these disclosures, ultimately there's going to be a level of um, diligence that's done on these sub providers, which is appropriate and a good thing to do. It's just how much is this extending the cycle, right? Are we adding people that are vendors that really don't need to be there? And of course, my children popped in right at my slide. So thanks, Val. I appreciate it.
All good. It's great that we had a question though, so we can
Yeah,
move
it
on
worked
here,
out
so.
perfectly. So Val already touched on the B2C, B2B, B2C context, but one of the things that I think is just really important as a practitioner is thinking practically about some of these dynamics and the context in which you're negotiating. Obviously, the deal size and the relative size and leverage of the negotiating parties is going to be a really big deal. The maturity of each party is going to matter. Kathleen talked a little bit about the TOMs. I think that that's something that's really important. If you're dealing with a really large organization, they may have a TOMs that they want you to agree to. And it becomes a question of like, can I operationalize this? What is reasonable? Is there TOMs out of date? Maybe especially some of the larger organizations, we sometimes see TOMs that you're like, that's not even really like current practice. My favorite is when I get a requirement to destroy paper by sending it to, the shredder. And I know that there are still people who use paper, but there, just thinking really practically about some of these sorts of things, I think is really important as we're thinking about negotiating these things. And sort of taking a reasonableness approach, like what is the data? Val was talking a little bit about the example with a webinar. What data is being exchanged? Is it really sensitive personal data? Is it your business name and email address? And sort of consider a sliding scale when you're thinking about these things. Maybe if you're doing a deal with a vendor that's going to have health data, you really are committed to getting really tight toms and commitments from those folks, because ultimately you can't put the toothpaste back in the tube. But maybe it's a standard SaaS vendor where all they're really getting is business name and email address. And while that's still personal data and you should have a DPA that's appropriately allocating the risk, maybe it's a lower risk proposition than the PHI. I do see a question. Could we elaborate on the key considerations that differ between B2B and B2C contexts? Yes. So ultimately, and I'd like to open this up to other folks on the panel as well. My primary experience is in B2B, but I do find that when I'm negotiating, um, uh, if it is a vendor or a customer who has a lot of B2C experience, some of the concepts that they get really stuck on are less relevant in a B2B situation. I think that when you're thinking about a B2B negotiation, the risk, again, getting back to sort of those practical risk allocation matters, the risk is a little bit lower, because if you think about sort of what the regulators are targeting currently, it's a lot of consumer facing businesses. And so I think that the stakes are just higher if you're in a consumer facing business.
I really like that point. And I'm really glad somebody asked this because I was going to just ask anyways of the panel. It's a great point. I mean, look, there's a lot of considerations, and it goes to like, it's the ultimate leverage dynamics point, right? A consumer has it's under the law, and Dave, please keep me honest here, right? As the resident external counsel, consumers fundamentally have less rights than businesses, right? And they are fundamentally not less rights. They're considered to be less sophisticated, rather. And because of that, it means that businesses have a pretty high onus and burden to make sure the terms are clear, make sure the terms are easy to read, make sure that they're not onerous. And there's a negotiation point, right? Like, can you even negotiate with a consumer? Can a consumer even be a controller? There's a lot of stuff that you really do have to consider if you're selling to B2C businesses or directly to a consumer, in your own business. But Kathleen and Dave, what are your thoughts?
Yeah, no, Val, I think you made an excellent point. As someone that's drafted a number of privacy policies and also worked on DPAs, as a mortgage loan originator, when I was there, like we were direct to consumer, and privacy policy or our GLBA disclosure was only like that was the area where we had the chance to tell consumers what we did with data. But we had to do it in a way that was digestible for a broader audience, and you're not necessarily negotiating against a lawyer, you're not negotiating. So I think transparency and being able to say it in plain language is so much more important in a B2C relationship versus a B2B relationship. And understanding that like I said, it has to be plain. I won't get too much into it because we'll get further down with it with the DPA, but you have a chance to get more sophisticated if you are negotiating with a fellow attorney that might be another SaaS attorney at a different company that's specifically focused on privacy and understands the intricacies of your tech stack and where the data is going versus like somebody that's just applying for a mortgage online that is like, where's my data going and what's happening? So that's a really good point. Thanks for bringing that up, Val.
Yeah, and what type of consumer data are we talking about? Because if it's my name and my email address, that's one thing. But if it's my name and you're in the mortgage origination business and it's my name, my financial history, my social security number, obviously a higher risk there for class actions or regulatory enforcement if there is a data breach of some sort.
Cool. Okay, you want to keep running with the rest of these?
Yep. So again, I think that I think the last point really on this is what can be operationalized. I think we went in a little bit of a not in directly in order, but I think we touched most of the key points here. Ultimately, if can you operationalize the process that you're committing to or that your customer is asking you to commit to? Sometimes when we're negotiating these things, it ends up in particular, if you're on counterparty paper, in particular, I find it with the TOMs, right? Is like, do I have to create a business process just for this particular customer or just for this particular relationship in order to live into the commitments that this person wants? Or can we find a middle ground where we're meeting the needs and the requirements of the law based on the data and all of that, the sort of those sliding risk scales that we talked about, but that I can also operationalize without having to go build a whole one-off process that's probably manual, that's probably difficult to maintain, and sort of, what are the trade-offs here that we can find that sort of lands in a place where I can live into the commitments, do right by the customer or the vendor, live into the relationship, but also manage my business.
We have two really great questions. I want to power through these to make sure that we have time for the rest. I'm going to go a little bit out of order because there's only two right now. But the second one was, let's suppose a vendor has access to customer information, but they can only see/view the data. Is this still processing, and should there be a DEPA in place? The short answer is yes. I mean, there's a lot of things you still have to consider. Totally outside of privacy, but just because I, used to pretend to be an export compliance lawyer too, is there's still deemed export considerations if your data is being viewed somewhere else. So you have to think about it from a bunch of perspectives, including privacy. If somebody in another region of the world is able to view that data, there's still a processing occurring, even if there's not actual modification of that data. It certainly speaks to some of the things that Kate's talking about, and some of the things we'll speak about in the next slide about scope, in terms of your risk assessment, but it doesn't necessarily alleviate the need to still have certain things buttoned up. And then the next one is really great, so I think we could do a round.
Can I take that one? Sorry, I was like, I want that one. I think that's a really great question. I have predominantly been at sort of smaller organizations, and so I've also been in that situation, and I think that it really comes back to being able to have a conversation with the customer about what you can operationalize. Like, hey, we'll talk a little bit later about sub-processors and specific versus general consent. Like, I don't have the humans to operationalize what you're asking for. I don't have I would have to go procure a tool in order to live into sort of what you're asking for. Can we do it this way in order to give you the comfort and confidence that you need that we're doing the right things, but also so that I don't have to re-architect kind of how we live and run our business. I've found that to be a very successful talk track, because oftentimes the person on the other side, if they're not sort of in the same seat of having to operationalize those commitments, they sit next to the person who is, and so it's a relatively accessible concept.
And Kate, you're thinking in terms of where you're the smaller vendor and it's a big customer, right?
Yeah.
And so then on the flip side, if you are a big vendor, sorry, if you're dealing with a big vendor and you're a small customer and your vendor has like a take it or leave it type DPA, what are approaches there? And my thought there goes to, like, what's the legal requirement? And that may be the best you can do, right? So if you think that the DPA is legally deficient because you as a controller or data owner have to comply with GDPR or GLBA or HIPAA or whatever it is, and I think you can point out these are the things that are missing that are legally required. That may be the best you can do, and maybe is doesn't ameliorate your risk to a sufficient level, but that may just be the best way to go about it.
Don't ignore what Dave just said, folks. Like, I think that the subtext behind what you just said is super relevant, which is that sometimes when you're dealing with a blue chip large, whether it be customer, let's say vendor, if you say, hey, I don't see a CCPA provision in here, the salesperson might be like, oh yeah, I have that addendum, and they just have access to it. And so like sometimes asking for those types of things isn't necessarily that head-butting moment that we all fear it is, because they know that people might ask for 20 different things and the sales team might already have a repository if it's a sophisticated organization. And so using that lever that Dave just described is really helpful, because typically if it's a big mature org, they know that that's coming, and some people might ask and they might already have a, like, for the salesperson you're speaking to, like a self-service capability where you don't need to go to, somebody in legal from that organization.
And just to expand upon what Kate said, I would say make sure the right people are at the table if possible, because with larger organizations, you're usually dealing with procurement and the buyer, and maybe privacy legal and commercial legal, and it might be like a whole smattering of different hands in the pot, so to speak. But if you can really get to the person that is trying to understand like what your tool is and how to operationalize it, sometimes they can have that conversation internally and can point out where they might be a little bit you know stubborn that they need not be. If someone can explain it to them, then they don't feel like is the opposing party that's like, no, this is what our tool does, right? So finding that you can get the right people at the table, I think, is also really helpful.
Definitely agreed. I think that the two things that I'll leave folks with are that a lot of this dynamic stuff in general and small, big business relationships has frankly more to do with corporate culture for organizations than you might appreciate. And what I mean by that is you could have two behemoth companies, and if one of them has a really like toxic or resistant vibe, regardless of regulations, it's going to be hard to get through. And then, there are other companies that are very reasonable. They're either reasonable because I won't name names, but there are some blue chip companies that actually have very good terms. Like, they're huge and they don't want to see what your edits are, but what they give you up front is incredibly reasonable, which is kind of back to what Dave was saying. And then there are other companies who have crazy things, and it becomes a little bit of a challenge. And I think that I would just tell you, and maybe hopefully this is a little cathartic, that might be more indicative of those organizations sometimes, and that they might have those views regardless of your size, and they may be inflexible regardless of your size. And I think that it is a little bit of a risk balancing act between what Dave said, which is like, what are your legal requirements? As well as like, how much of this is ego, right? That's the other thing to really think about here, because I think sometimes all of us legal and legal adjacent professionals want things to be worded a certain way. And I think thinking about whether or not what you're doing is about wordsmithing versus like operational things, like if they, let's say you're the vendor and they say you need to have state-of-the-art, cryptography that you don't have, that's a factual issue, right? If you sign off on that, you're breaching the contract, you create rev rec issues, you create clawback issues, whatever, and legally, same thing. Versus somebody says something that, it's worded a little differently than you like. I think it's all worth considering. But the reality of the situation is that, sometimes whether we're big or small, we have to, fight the fight. And the reasonable organizations on the other side will do what they can, whether it's through their sales org and another template, or because culturally they're willing to accommodate. And some won't, right? Some can't because they are in heavily regulated spaces, defense contracting or whatnot, but some won't because, they decided that. So I think company culture is really important to consider too. And I think everybody in this panel has worked with really excellent buyers and vendors. And then we've also worked with folks who are just, sort of headstrong and won't bend on anything. And one more question. I see a couple of people going off mute here. So Dave or Kate, if you want to take that one.
This is another passion point for me,
Go
for
ahead.
what it's for what it's worth. I think that one of the things that I'm so passionate about is you have to understand the technology, and that means that you're probably going to ask a lot of questions. I think as I'm counsel, right? So I think that one of the things that is so critical to being successful, whether it's a negotiation with a customer or whether it's a negotiation with a vendor, is understanding how the technology works. And so in particular for AI, in a marketing context, like really digging into what is this thing doing? How is the data flowing? And then once you sort of have that understanding, I think you can make a much more reasonable risk assessment about things like the data and the toms and those sorts of things with respect to the AI.
Yeah, absolutely. I think that, and let's just call a spade a spade. AI is new. There are things that are still being figured out in AI. And even if somebody places a beautifully written clause that says that your AI shall be unflappable and shall never do anything and shall be free of all IP issues, I think that you're kind of putting everybody, oftentimes when people do those things, with the exception of the extremely blue chip companies that are building those AI LLMs, you're effectively putting vendors in a situation where they either will tell you what you want to hear sometimes, which feels good because you can close out the contract, but they may be being disingenuous because of the fact that, some of this is a little bit of a black box. And so I think beyond what Kate is saying, I think acknowledging that AI itself is so novel that there are so many different ways in which traditional privacy expectations could go sideways, that it's partially about your vendor, but it's also partially about your internal controls. What are you submitting into it? Well, how have people been trained on it? What are you procuring? Like, do you have a provision that says the model isn't being trained, and so on? So thinking about those things from both. And by the way, that's the same with all security and privacy stuff. Like it's sometimes about what you control through paperwork. It's also about, training your employees, making sure that they understand the limitations of AI, making sure that you have awareness training that talks about not throwing things into the ether on a free version of ChatGPT if it's highly sensitive to the company. So just thinking through some of those things.
Should we
Um,
start
So
getting
the
into our
time check,
provisions?
Val? Yeah.
yeah, I see another question, but let's keep going just because I'm a little, yeah, we are running short on time. So some of these are probably quick hitters, so I'll go through this one quickly. Scope is really important. I think we've touched on that in a couple of different ways. But before you kind of raise all alarms when you're going through contracting, understanding the scope is really important. Somebody had asked about what about just viewing data? Dave had mentioned just business information earlier. If somebody is like read only and looking at like business contact information, that might be a fundamentally different situation in other, versus a electronic, medical records system, right? In terms of volume, in terms of processing, in terms of scope. So really thinking about kind of what's happening here, how much of it's happening, what the true risk is really critical before you kind of think about what needs to be edited or negotiated or even what template you might want to use. Let's move to the next slide here.
All right. One thing too, as we go through these, would be interested for the comments from the attendees, like if there are other provisions that you see like sort of heavily negotiated. Yeah, I'd be interested to see those if you can drop those in the Q&A. So limitations on use, kind of similar with scoping. You'll see that for, I think, the rest of these, we include a reference to the GDPR. Yeah, as we said at the outset, not unique. I mean, there are other data protection laws that we can point to and regulations that require some of these provisions. But here's and I guess also not surprising that a lot of them reference Article 28, right? The requirement for a DPA. So limitations on use, the back and forth sometimes we see is it broad or is it limited? What are the potential future use cases? I mean, kind of getting into like the AI questions as well, right? Like, can you use de-anonymized data for training different models? So how are you limiting the vendor's use or the processor's use of the data that's involved?
We did run a little long on some of these. So all right. I'm gonna go through this. Let's see here. Somebody had a question about. Okay, somebody was just sharing that they're seeing a lot more information about data encryption processes more recently. So yeah, I think that's a super helpful point. I think it's absolutely true. I think especially in light of the EDPB decision, guidelines after the Privacy Shield fell, people started thinking, people in the privacy community, the security community has been thinking about it for some time, started to realize that encryption is not a panacea, and encryption can mean encryption managed by your cloud provider, encryption managed by you, encryption managed by the clients. And I think that it has required and continues to require people in our space to get a lot smarter about what encryption means and how it's done. So anyways, moving on to sub-processors. I'm just going to click answer live here. Thank you. So we talked about it a little bit earlier with sub-processors. Typically, these are those downstream vendors that we talked about earlier. I won't retread on what we discussed in terms of who they are. They could be called service providers or sub-processors. They could be called business associates, etc. But under a number of privacy laws, including GDPR, there are requirements that you can't just willy-nilly add downstream vendors whenever you want, right? And typically the way that you might see those is you might see provisions on the contract that, Kate, you were talking about this the other day, they call them contractors. But if you're a SaaS vendor, like you might not have contractors per se. It's really about the downstream use of information from whoever you're contracting with. And some of the typical ways that you'll see organizations handling this, proposal of new downstream vendors is through something that's called either general authorization or specific authorization. Let's talk about specific authorization first. That's really simple. That is, let's say I'm performing a service for Dave, and I say, Dave, yesterday I was using Amazon for my hosting, and tomorrow I want to use Oracle or Microsoft or somebody else for my hosting. I'm going to tell you who that is. Is it okay for me to shift over? And Dave gets to decide if that's yet okay or not. That's basically what special authorization is. You'll see that frequently referred in a contract as like, thou shall not, send data to a third-party subcontractor or subprocessor without consent. This is really a scale issue for a lot of organizations. And it sounds really good if you're the customer and you give somebody paperwork that says that. But for companies in, for example, the SaaS space, where they're selling COTS, right, commercial off-the-shelf goods or software, that doesn't really scale or work, which is why you'll see most of the leading SaaS companies in the world use general authorization. What general authorization is, and Kathleen spoke to us a little bit, so hopefully things are starting to click a little bit, is typically you will have a disclosure online of, and maybe in your contract, of who the present state vendors are or subprocessors that you're using. And then you will have some kind of protocol to notify if there's a new addition. Typically that protocol involves at a minimum updating that web page to have the new ones, some period in advance, typically 15 to 30 days is common. Most people don't really want just that. They want some kind of like push notification too. And so I would say that like a good practice to consider is providing through automation or through some kind of subscribe link, a subscription capability so that if you make a change to your subprocessor disclosure, you send an email to people saying, hey, we've changed this. You have a period, let's say 30 days, if you have any concerns. And typically the process goes that if somebody does have concerns, they have the ability to object. And then you will typically go into some kind of like adjudication period where you either can work around their concerns, not use the vendor for that person, or in worst case, often people will offer a termination right if they can't kind of overcome those challenges. I think that in my experience, I see some questions about audit, so I think we'll talk about those in a minute. And yes, somebody asked, would a downstream vendor include AWS, Google Cloud, etc.? I mean, the short answer is it depends on how you're using them. But if you're using them to host your software service and they're handling data on behalf of your clients for you, then yes, they would be considered a downstream vendor. Anything else to add, folks, before I move on to the next ones? Because I see some questions on. Oh, sorry, I see one more
Well,
here. Yeah, Dave. Go ahead.
I guess as well as Kathleen and Kate, I mean, how do you see customers objecting when adding a new subprocessor? And how is that? Any anecdotes on how that works out?
I mean, I've been doing this a long time. I've never gotten an objection.
Same.
But I so
Same, by the way, same.
Yeah, no, and I mean it's like I that sort of reinforces what I thought, which makes the whole thing a little bit what are we negotiating over here, right? Like at the end of the day, we're not you're not going to add some like if you're a reputable company, you're not adding some fly by night entity, and so um, sort of it reinforces some of the comments at the outset about sort of like what's the maturity of the organization, and like let's sort of be practical here as we negotiate some of these provisions.
Personally, I think there's a little bit of chest beating going on with this provision. I think it's one of those things where you're absolutely right. And I think that, when you're talking to somebody like the folks on this call, Kathleen or Kate, who have, worn multiple hats in an organization, they know that. But I think if you're speaking to somebody whose sole responsibility is supply chain management or like reviewing privacy agreements, they might not have the wherewithal to appreciate that point, right? It might be somebody else in the organization. And that's where there's a little bit of challenge because you have this person who's got these really defined parameters. And I think that speaks back to the dynamics point where like your process is your process. If you are a SaaS company with hundreds or thousands of clients and somebody comes beating their chest and saying, no, I want specific, I want to consent to each one of these, it's a scale issue to be able to say yes to that. So even if they really want it, unless you're choosing to re-architect your business, there are going to be serious challenges with you actually committing to that. I see about 12 minutes left and I see an audit question. So I think we maybe power through incident notification. Remediation
Yes,
as well.
Val, there was an incident notification one. So if we maybe go to that, I can talk through it.
Yeah, let's do it. So let's go to the next slide on incident notification.
Yeah, so there's been some back and forth in the chat, which is really helpful, and thanks everybody for putting in your own sort of perspective on what you see as commonly negotiated provisions. So security incident notification requirements. Here's the Article 33 requirement from the GDPR. The requirement in the GDPR is without undue delay. There is a reference as well in Article 33 to 72 hours, but that's 72 hours for the controller to notify. The processor obligation is without undue delay to notify the controller. So I frequently see the 72 hours in agreements, and I've advised customers, I've advised vendors, and no one is really. I can see it from both sides, right? Supply chain incidents, third-party incidents are a fact of life. We see them quite a bit. And when you are on the vendor side, you've got every single customer beating down your door, asking for more and more information, right? And then when you're on the customer side, you're just you can't get enough information from your vendor about the incident. So I completely see both sides of it, and I think it just matters which side you're on, and also reflecting like what is the data that's being processed. Are we going to define a security incident as suspected? Well, if you define it too broadly, then arguably you need to notify about every phishing email and things that aren't actually material. So I think somebody else is going to share a perspective on this.
Yeah, I have a lot to say about this one because I've seen it from a number of different organizations and like have had customers and been on the side of like more heavily regulated entities and those that are not. And my advice would be please know the law, know what is applicable to you as the controller versus what your processors, what's applicable to them. Because I've seen everything from 24 to 36 to 48 to 72 and everything in between. And so, without undue delay, if that is what the law actually says for your processors, know that, because I've gone like tooth and nail and to the mat with people on, 36 hours is the requirement. I don't know what regulation references 36 hours. I really genuinely don't. And I would also say this on either side with your contract templates, let's come to the table with a reasonable approach. 24, I have worked for huge organizations and very small organizations. Operationally, if we're going back to the point that Kate made, no security team or legal team is going to have their act together to get 24 hours, and I don't see that in a regulation either. So be reasonable in your stance when you come to the table, because I think we can all find like a middle ground here. But this is something that is so heavily negotiated, and people dig in their heels when it should be based in the law, based in fact, and your company's security stance. And maybe you come to a point with a vendor that if you have to have 36 hours, that vendor isn't the right vendor for you. But think about your stance, like operationally, with your security team, with your legal team, what's in your contracts, what you can operationalize. It's something to genuinely sit down and not just be like, of course, we have to have all the information as immediately as possible. Immediately, also, like, can we get away from immediately, please? Because I don't know in what world that is going to be something that's like so easily operationally like feasible for everyone. So I don't know. I feel very, very strongly about this and could say a whole mouthful. Does anybody else want to add to it?
No, we appreciate it. And I think honestly, candidly, it's a little bit of a chest beating issue too, where sometimes this one gets a lot of airtime in negotiations. When anybody who's actually been in incident response, I know Kate and Dave and Kathleen certainly have as well, like knows that like how incidents actually work and all these things is incredibly complicated. And so like when somebody suggests like, I've seen 8-hour notification windows. And to me, that suggests that they don't really understand what it takes to respond to an incident or how an incident plays out or what it actually takes to understand the scope and impact of the incident before you reach out and notify. And I think that speaks a little to suspicion of an incident in general or to the user. Like there's all this nuance that I think folks who have not lived in the cyber world probably don't appreciate. Okay, it looks like you went off mute.
Yeah, no, the only other thing I would say is, I mean, conversely, right? Like, if that's something that's really important to you, like 24 hours or suspicion, to somebody's point, I think it was Dave, like, you could be opening yourself up to a ton of work, right? Like if your vendor is notifying you of every single phishing email, not that they could operationalize that, but let's say that they did, like well, then what are you going to do with that information, right? Like, are you going to go then investigate the vendor every single time they're like, or are you just going to keep a Rolodex? And that, like, it just, I think you just sort of like end up in this place of like, you sort of can't see the forest for the trees in some situations when you're asking for more in like that level of information.
So looking at the time here and looking at the fact that there were some questions on audit, I suggest we skip to audit, and if we have time for indemnity, maybe we cover it. Dave, you want to kick us off?
Yeah, sure. So you see here, Article 28, allow for and contribute to audits, including inspections. So it is audit rights are a provision of the GDPR. However, operationalizing this, and this also actually kind of goes back to my point about objecting to sub-processes, right? Like how frequently do you see companies actually invoking their audit rights and carrying through on them and going and conducting an in-person inspection? But there's plenty of room for negotiating what the audit right provision includes, right? So is there a non-disclosure agreement required before the customer can execute their audit rights? Is there a timing requirement, right? Like you need to give such and such amount of notice before doing it. Is there a provision about who's actually going to pay for it, right? Like if your customer is going to conduct the audit of vendor, well, should they be paying for it? And then is there room for instead of a ability or right to conduct an inspection, can we provide our SOC 2 type 2 report by a third party or our ISO 27001 certification conducted by a third party? I mean, I think that's sort of the more practical answer, right? Is provide the SOC 2 type 2 audit, provide the ISO 27001, actually review it, right? And see if your vendor is meeting sort of the standards that you would expect through that third party audit.
The thing that I wanted to highlight here is, and I'm really glad that Dave, you put the actual verbiage from GDPR. It doesn't say what I think that sometimes people think it says. It doesn't say you're allowed to kick down my door and like shake us loose for change any minute, right? That's not what it says. And it doesn't say that for a very good reason, because it's not what it's intended to say. It's really intended to be a mechanism to check that things are happening the way they should. And there are lots of reasonable ways to do that. But again, depending on the dynamics of the organization, depending on things like the spend, the scale of your business, and so on, you really need to think about like, A, what kinds of reasonable, like accessible things you can do that reduce some of this. Like David mentioned, SOC 2 and ISO. Somebody else reputable, right? I mean, if you've used a qualified auditor and all that, came in and did this. So that should provide some level of comfort. If you need things above and beyond that, one way to handle that in a contract would be to basically create an open-ended statement that if something warrants auditing above and beyond what you make readily available as a vendor, that it's mutually agreed upon between the parties. Another thing you could do if you wanted to get kind of more structured is that you could put additional limitations in place, like it'll only happen once annually. My only caveat with that is that you really do need to be careful with once annually, because if you have, God forbid, a data breach or something else happens, like extenuating circumstances, the client's not going to care that you said once annually in the contract. So I would think about kind of rates and reasonableness in that. But it is reasonable to push back on overbearing, in my opinion, overbearing audit provisions, because there isn't necessarily a law out there that says, you know, just because you buy a $100 tool online, that you're allowed to go inspect Amazon Web Services facilities, you know, with a 24 hours notice.
Val, would you like to maybe just go through these last ones in the last 2 minutes? If
Yeah, let's power through indemnity. I know we've got really good questions. You know, we could have made this a 3-hour session. We'd still wouldn't run out of time. But Marie, could you go to indemnity?
Yeah, so here we go. So I think the takeaway here on indemnity, and I think that in preparing for this, we all agree, putting indemnity in your MSA or your SaaS agreement, and taking out the DPA at least is what I prefer. So it's addressing not just indemnity for DPA violations, but for the agreement at large, you know, potential IP issues or whatever it is. You go to the next slide, please. Standard contractual clauses, certainly room for negotiating here, not on if they apply or not. I mean, we have the modules already, but do the optional clauses apply? What goes in the annexes? Adequacy decisions, and that being, do you enter into an SCC even if there is an adequacy decision in case something happens with the adequacy decision? Next one, please.
Yes. You want to go through this one, Dave, real quick? So this is, look, you know, typically whether or not you're B2B or B2C, there is a likely downstream end user. And, you know, if you're dealing with a B2B business, for example, they might have a downstream end user who's using their products. This is really about enabling them to fulfill their rights. If you're selling a HRIS tool, like a Workday tool, they might have employees who reach out to their employer to say, I want a copy of the data. So you might need paperwork in place that says that, you know, if those types of requests come in, you'll help facilitate those requests. People do frequently discuss timing and level of assistance, etc. In my opinion, that is a bit of chest beating, but it is important to think about data export and actually the ability to provide that assistance. And I see that we're at time. Tom's was the last one, but we did cover those. I wanted to say thank you to everybody for joining. Apologies that we ran out of time, but you know, it means that we had a lot of good questions. Slides will be shared and this recording will be available afterwards.